welcome to Off the Clock, a podcast by Prosino Wells and Woodland, where we take a team-centered, family-focused approach to serving the estate planning and elder law needs of our community in Delaware. I'm Mindy Cooper, Director of Estate Planning at Prosino Wells and Woodland, and I'm joined today by Amber Woodland, one of our managing partners. Today we're jumping on a trend, TOD deeds. We had a client recently call them a Todd deed, so we might refer to them as a Todd deed. We're excited to share our take on this option to help families feel informed about their options. So let's get started. Amber, Delaware recently passed a legislation allowing transfer on death deeds, and we're seeing a lot of interest in our community. As it relates to our work, one of the most common questions we're hearing is, should the Todd deed strategy replace the use of my trust? I'm excited for our listeners to hear you unpack this today. Can you start by explaining what a TOD deed is and why Delaware residents are so curious about this new option?
Thank you so much, Mindy. And I'm excited for this episode of our podcast because this has really been buzzing around. I know you're hearing it from clients. I'm hearing it from clients. I'm hearing it even from other professionals about the new Delaware transfer on death deed. So I'm excited today to just offer our perspective on this new legislation and also just kind of debunk maybe some myths and hopefully educate our community about some reasons why we don't believe TOD deeds are usually the solution. So hopefully through this episode, you're going to get some true education about our perspective and why we think trust are better options. But I think we do have to start with just explaining, what does TOD even mean and what even is a deed? So most people know what a deed is. A deed is a document that transfers real property, or most people refer to it as real estate. A TOD deed is where a person can actually add a transfer on death beneficiary to their real estate. So a transfer on death deed is essentially a way to name beneficiaries on real estate, much like you could go to the bank and name a TOD beneficiary on your bank account, or you could name a beneficiary on your life insurance policy or on your retirement account. Essentially, when the owner of the real estate passes away, the TOD deed would describe who then receives the property upon the original owner's death. So when a TOD deed is signed properly and recorded, it's naming beneficiaries as to who will receive your real estate immediately upon your death. And why I think it's creating such a buzz is because everyone knows that a TOD deed avoids probate. And most Delaware residents want to avoid probate. And so they've been curious about, okay, how can I avoid probate using a TOD deed, maybe instead of using a trust as part of my estate plan? So they kind of view it as like an easier, more inexpensive solution than creating a full estate plan. But we kind of feel like it's really all in the details, and we're going to help kind of educate you as to why there are some insufficiencies with just simple DIY TOD deeds.
The basics, let's start there for our listeners who may be hearing about a TOD deed for the first time. So what exactly is a transfer on death deed?
So we as lawyers never like it when the legislators put actual forms in our statutes, but the TOD deed is an actual form. And I spent some time reviewing the form that is available on all of the Recorder of Deeds websites. And it is a legal document, but it is set up and designed as a fillable DIY form directly on the Recorder of Deeds websites, really intended for the current property owner to complete it himself or herself to designate beneficiaries on their real estate when they die. When that owner is completing that form, they are retaining complete and total ownership of their own real estate at the time that they complete that TOD deed. But they're essentially saying, when I die, here are the named beneficiaries or the transfer on death beneficiaries that I want to receive my property at my death. These TOD deeds are completely revocable. So if a person creates it and then changes their mind about who they want to receive their property at their death, the TOD deed can be completely revoked and replaced with either better estate planning like a trust or with a different TOD deed. But I think it's critical to point out that the beneficiaries that are named, just like beneficiaries on a bank account or a retirement account or a life insurance policy, have no ownership rights or access or control or expectancy rights until the person dies. Because of the revocability of this TOD deed, it really doesn't take effect essentially until death. It's just a designation. And then that TOD deed, what's interesting about the form is it has to be properly signed. It has to be properly witnessed and notarized. It also has to include a legal description of the property. And then it has to properly outline those TOD beneficiaries. It also must be recorded. So my concern always with fillable TOD forms is that someone's going to attempt to DIY this and make a mistake and not do it properly as outlined in the statute and have a false sense of security that this form that they've slapped together is all they need to do in terms of their estate planning. And then we don't find out till it's too late that there was actually a mistake made at the time that it was created.
Mhm. How does it work practically? What happens when someone passes away who has filed a TOD deed?
So upon the property owner's death, ownership passes immediately and automatically by operation of law to whoever is named as the beneficiaries in that TOD deed. There's of course some necessary filings to essentially clear the chain of title to the real estate, but it does happen immediately upon the original property owner's death. So typically we would file a death certificate to report the property owner's death. There's likely going to be an affidavit that has to be filed to just show clear chain of title that the original property owner has died, but the beneficiaries then own the property immediately and outright. So if there's multiple people, which this is going to be a common theme of today's episode, if there's multiple people named as beneficiaries, then those multiple people immediately become owners of the property as soon as the original property owner has died.
Why do you think this option has become so popular?
I think because it's perceived as cheap and easy. And I worry about that because we're all kind of suckers, if you will, to saying, oh, yeah, I definitely want to avoid probate. And this seems like it's going to be easier and more cost efficient to allow me to avoid probate. And so I think it has created a lot of buzz because it is perceived as a DIY strategy or tool to avoid probate. But look, we've been doing this for a long time, and we've heard all of the horror stories that can come out of DIY planning. And I just am so passionate about the work that we do and the community that we serve. I just am so afraid that this is not going to be a one-size-fits-all solution, or there's going to be major blind spots for people that they don't even know they're missing because they're uneducated about this potential strategy, or they're uneducated that there are some alternative, better planning opportunities out there. So, when we are comparing a TOD deed to creating a comprehensive estate plan, I think the perception is, oh, TOD deed sounds so simple and easy. A comprehensive estate plan sounds more cumbersome, more time involved, more money spent. But in the grand scheme of things, having a full comprehensive estate plan is always going to be a better option because you're not just focusing on the real estate as the only asset. You're thinking about it as a comprehensive, what are all of the assets? Have we considered all of the family dynamics? And we can still avoid probate, but by doing better, more thorough estate planning.
So let's jump into our list of concerns. We'll take these one at a time,
Okay.
starting with Delaware residents who own property in other states.
All right. So for anybody that knows me or is getting to know me, they know that I am a huge Disney fan. If I could be in Florida all the time, that's where it's my happy place. I can really just relax and just be a kid again. But I own a Disney timeshare in Florida. So if I, as a Delaware resident, put a TOD deed in place for my Delaware property, I could potentially still have a probate issue when I die on my Florida property. So believe it or not, timeshares, just like vacant lots or other real property interests, are all considered out-of-state real estate, subject to a process when we die called ancillary probate. That means that if we die a Delaware resident and we own property in another state, that property is still going to have to go through probate in that other state. So we have lots of clients that are Delaware residents with real estate in other states. They might own a beach house in Ocean City. They might own a condo in North Carolina, whatever it may be. And if they're just looking at this through a narrow lens and saying, I'm going to put a TOD on my Delaware property, and they don't think about what they're going to do with their North Carolina condo or their Florida timeshare or their Ocean City beach house, they still have a probate concern and they still haven't covered all of their bases. So anyone that has interest at all in real estate in other states are still a better candidate to use a trust as part of their estate plan, as opposed to just simply looking at this one specific Delaware piece of real estate and thinking that it's one and done.
Yeah, so let's dig into that. So if a client used a revocable living trust, how would that address multi-state property?
So the great thing about having a trust, so just continue to use me as an example. If I have my revocable trust as a Delaware resident, I have deeded my Delaware residence into my revocable trust, and I've deeded my Florida Disney Vacation Club timeshare into my revocable trust. So I have all my real estate, both my home real estate and my out-of-state real estate, all deeded into my revocable trust. And so we've got tons of episodes and tons of information about why we believe so much in using revocable trusts to avoid probate as part of your estate plan. But the best thing about a trust is it allows us to accomplish the goal of avoiding probate in all jurisdictions. So in Delaware and in all out-of-state, in all other states where there might be out-of-state real estate, and gives us a place where we can be more specific and more controlling about what that owner wants to happen to those properties when they die. And it also gives us a place to have all the other types of assets, land, bank accounts, and life insurance, and sometimes even retirement accounts, depending on the facts and circumstances. So the trust is not a complex or complicated tool. It really is designed to be a replacement for your will, to say who's in charge and who gets what upon incapacity and death. But it's a great place to title assets like your real estate, both in state and out of state. And then you have so much more control over what happens to those properties upon death.
Someone uses a TOD deed for their home. Does that solve their probate concerns for these other assets?
No, never. And I have personally done hour-long workshops and educational events to talk about adding beneficiaries to everything you own and how that's never a good estate planning tool. Overusing beneficiaries on everything, while it may avoid probate, can create a recipe for disaster, truly. So even if you went and you put a TOD on your deed and you put a TOD on your bank account and you had a beneficiary on your life insurance, a beneficiary on your retirement accounts, there are still issues that can arise. And I'll give you one primary example. If everything you own goes immediately to named beneficiaries when you die, we have a major cash flow problem. So we have no money in the pot, if you will, to pay for expenses related to that real estate or related to the decedent's final expenses, or to pay the final income tax liability or whatever it may be. And so then you have a situation where your multiple beneficiaries then are fighting with one another, because you might have one beneficiary who says, I'm going to take my share that I received and pay mom or dad's bills and make sure the house related expenses are covered. But you might have another beneficiary who's not willing to do that. And then you've got a situation where resentment and conflict builds between your multiple property owners. I also always like to mention tangible goods. You cannot add a beneficiary on jewelry, on collectibles, on firearms, on tangible personal property. And if the value of tangible personal property exceeds $30,000, it's still subject to probate. And the Register of Wills is still going to require your family to go through probate, even if you've got a TOD or a POD on every other asset that you own. So try not to look at this in single assets. More look at it comprehensively and say, I own more than just my real estate. I've also got cash accounts, I've got life insurance, I've got real estate, but I also have tangible property, and a good estate plan covers all of it. And I caution everyone against overusing beneficiary designations on their assets when there's a better tool, and that is the revocable trust.
You mentioned that the TOD lacks customization. Can you walk us through what that means in like a real life scenario? We kind of just touched on that a little bit, but.
Yeah, I mean, the TOD deed form that is available on the Recorder of Deeds website, it's very stagnant. You can't add contingent beneficiaries. You can't say, what happens if one of my named beneficiaries dies before me? There's actually very limited space for you to even put multiple beneficiaries. So it is, it's a form. And it doesn't allow for customization. So it's very limited. And a lot of our clients think about the second layer. So if they have, let's say, 3 children, they're not just thinking about their 3 children, they're also thinking about their grandchildren. And they're thinking about, what if one of our 3 children predeceases us? What do we want to happen to that child's share? Do we want it to go to our other 2 children, or do we want it to go to their children, our grandchildren? A lot of our clients include minor grandchildren as part of their estate plan. I would never encourage anyone to name a minor on a TOD form. That's also going to create a lot of issues. To put a minor as a beneficiary on a piece of real estate, that opens a whole new host of issues where the court would have to get involved if that minor inherited while he or she was still a minor, because a minor cannot own real estate, and the court would have to get involved in the potential sale of that real estate. So lots of limitations with the actual form that's in the statute. And I just caution everyone to be very careful and not to think about this as just one layer. You have to start thinking about all the what if scenarios, and a lot of those what if scenarios cannot be covered in the TOD form.
Right. Can you give us an example of how custom trust provisions might protect beneficiaries going through divorce, bankruptcy, or other financial challenges?
Yeah, absolutely. So if the TOD deed says, I leave my house in 3 equal shares to my kids when I die, we are not considering the what ifs of, what if one of them is going through a divorce? What if one of them is going through bankruptcy? What if one of them is on needs-based government benefits, or could become eligible for government benefits upon a future event? So a TOD deed, like I said earlier, it takes effect immediately as soon as that person dies, and it doesn't have any provisions in it to cover the what ifs. Our trust, in contrast, can always include provisions if it's important to the client that says, if my child is going through a divorce, I don't want them to receive their inheritance outright. I want their inheritance to be held in trust. An example would be, you die, your daughter's in the middle of a divorce, immediately inherits property through a TOD deed. It is likely that that interest in that property is going to be subject to marital property division. Instead, if you had a trust that owned your house, and your trust said, I don't want my share to go outright to my daughter, I want that share to stay in trust for the benefit of my daughter, with restrictions and control provisions, then it is unlikely that that portion of her inheritance would go through marital property division in that divorce proceeding. Similarly, like bankruptcy issues, if a child is going through bankruptcy and they immediately inherit an asset upon death, it's possible that it could be subject to the bankruptcy proceedings. If it's part of a trust, it's possible that it's not. So the trust just allows for you to include what I call the just in case or what if provisions. What if there's a divorce, a bankruptcy, or a needs-based government benefit situation? The TOD deed cannot cover any of that. it is a TOD deed is it's all or nothing, and it's right now, and it offers no protection whatsoever. So, I think that with the clients that we help, they often are thinking further about these what if scenarios. And so we are educating them that the TOD deed isn't the solution. And that's really the purpose of this episode today, is to just talk about all the limitations. And those are just some of them.
Yeah. Talk about what happens when multiple children or beneficiaries inherit real estate together through a TOD deed.
Okay, so in, Real Property 101, as a first year law school student, we learn about how real estate can be owned. And there is a type of property ownership that's known as tenants in common. This is just a fancy way of saying that when a person dies with a TOD deed and that property passes immediately by operation of law to multiple people, those multiple people, and I'll just stay with my example, 3 kids, own it as what's called tenants in common. They become immediate co-owners of the property in 1/3 interest. So they own 1/3 of the whole thing. It's an undivided interest of the whole. So each child now has a say as to what happens to the property. So if one child says, I want to hold on to this because this was my childhood home, or a child B says, well, I could really use the cash and I want to sell, and child C says, let's keep it as an investment property and rent it, you've got a potential conflict among those immediate co-owners. The worst thing that can happen with co-ownership is conflict like that regarding what we're going to do with the property. A trust, on the other hand, allows the original owner to outline specifically what they want to happen to the property. Do they want it sold? Do they want it put in an LLC so that it can be managed as a family beach home? There's all kinds of things that you can do through the trust that you simply cannot do. And joint ownership of real estate is just a recipe for disaster. And I caution anyone to use a TOD deed when there's going to be multiple owners that will immediately and automatically own it together, because you've got financial conflicts. You've got how's the property going to be used. You've got differing opinions about timing. You've got even the emotional component. This is the sentimental home that I grew up in. And the worst thing that could ever happen when multiple people own a piece of property is to have to go to court and force the sale. That's what's called a partition action. And that is the worst case scenario that I just never want to see families have to go through. So lots of limitations, potential family conflict.
How does a trust structure property inheritance differently to avoid these issues?
So it's very, very common in trusts that we draft to include, like I said a minute ago, direction to sell provisions. So I have a conversation with my client in the drafting and design phase, and I say, do you think there's going to be potential conflict at your death? Do you have a mortgage on this property? Do we need to sell it when you die? And if a client says, yeah, I want to take that decision away from my family, I just want to make that decision for them, I would like the property to be sold, we can include that language right into the trust, a direction to sell provision. And then it authorizes and empowers the trustee of the trust to then sell without getting all the other people or beneficiaries involved in the sale. So it's so much cleaner and easier. That's just one example of how we can customize and design a trust to make it so much simpler and avoid family conflict and have a plan for what's to happen. I mean, of course, Mindy, there's all kinds of other special drafting that we can do. We can give certain family members the first option to purchase. We can even offer them at a discount. We can give people right to reside, provisions. There's all kinds of creative stuff that we can do depending on the family circumstances, but that's the kind of customization you get when you work with a good estate planner, as opposed to DIYing and using a fillable form. So, just be careful.
This is a big one. Can you explain how TOD deeds affect long-term care planning? We have a lot of that in our firm, so.
I'll try to keep it brief because I get very passionate about this, because at Prosceno Wells and Woodland, we always educate our families about planning to protect their assets from long-term care. And it's not always a fit for every family, but Mindy, I know you're very good about educating families when they come in for their first meeting about what it looks like to pay for long-term care, how expensive it is to pay for long-term care, and what the planning strategies are to potentially shelter their assets from that cost. And so we educate our families a lot about protecting their home from the future cost of care. So in Delaware, it's about $15,000 a month to be in a nursing home right now. That's, in 2026, that is the current cost that we see on average in our local nursing homes. And the worst thing that could happen is for the home to have to be sold or the home to be subject to a lien if nursing home care is required in the future. So a lot of our families elect to move their home into an irrevocable asset protection trust. And after 5 years, the full equity value of that home is sheltered from future long-term care costs. The TOD deed does nothing to protect the value of the home from future cost of care. So all the way at the beginning of this episode, I said the owner retains control. They can change and revoke the TOD designation. So what that means to the state of Delaware, if that person needs nursing home care, that person's in control, and that person can still sell that property, and that person can still use the value of that property to pay for their long-term care needs as they arise in the future. So I just never want anyone to have DIY'd a TOD deed and have this sense of, I've done my planning. My largest asset is protected. I don't have to worry about anything. We don't have to worry about probate. That was so simple. And then be kind of blindsided in the future, or their family blindsided in the future, that the value of their largest asset, which is usually their home, is not protected from their long-term care costs. So be very careful. And again, remember the TOD deed is really just doing one singular thing, and that is potentially avoiding probate on the value of your Delaware real estate. It does absolutely nothing to protect your home from the cost of care during your lifetime.
We've been hearing a lot more about deed fraud lately. How does that factor into this conversation?
Yeah, I think that's another good thing to bring up and just kind of mention. We had been kind of getting a flurry of questions about deed fraud, and you know why I think it was because there are people on TV and on the radio advertising their services to, protect seniors from deed fraud. But in Delaware, they're actually monitoring services. You can actually enroll through the Recorder of Deeds website for an alert if something happens and your deed is transferred without your permission. There's fraudsters out there. There's always bad guys. And, this whole thing with deed fraud is the bad guys are out there trying to transfer property that they don't technically own by forging your signature, transferring your property without your permission, and even sometimes without your knowledge. And, even when you have title insurance and you're protected and it can be undone, it can be a real nightmare. So I want to be really clear that the trusts that we use don't ever prevent deed fraud, but I kind of liken it to this. If a criminal is walking past multiple homes and one home has a dog and a security system and one home doesn't, it is likely that the criminal is going to pick the low-hanging fruit, right? The one that looks easier to burglarize. And I kind of see the same thing with deeds. If a deed is in a trust, it is not the low-hanging fruit, because it's not going to be clear to the criminal, oh, how do we transfer? Who's the trustee? What does it mean that this property is in a trust? And I think it gives a little bit of pause, as opposed to, or in contrast to, a deed that is still in a person's individual name with just a TOD on it. I think that's the low-hanging fruit. And I think that's what the criminal's going to go after all day, every day, as opposed to going after a property that's titled in the name of the trust. So I'll say it again, trusts don't prevent or protect against deed fraud, but I think it creates a little bit of a veil of protection from those criminals that are looking to commit the crime and try to transfer property that isn't theirs.
So help our listeners understand who might benefit from a transfer on death deed and who really needs the comprehensive protection of a trust.
So there's going to be someone skeptical that'll listen to this and think, oh, Amber's just trying to sell trust. And I don't consider myself a salesperson. I really do consider myself an educator. And it is my job to educate this community that I was born and raised in about the best planning that they can do. And I wholeheartedly believe that the trust is always going to be the far superior, better estate planning tool. But I think you're asking the right question. Is there a time and a place for someone to create a TOD deed? Probably. You know, a really simple matter, a really simple case, you know, maybe a one beneficiary situation where there's not multiple co-owners. Possibly. There might be a situation where a TOD deed makes sense. But from my perspective, it's going to be a very limited circumstance. And I expect that I will rarely, if ever, utilize TOD deeds in my practice, just because I know the better tool, and the better tool is always a trust. I like to say this too, Mindy, to my clients. You want to know what I have as my estate plan? A trust. So it's like, you know, if the lawyer is using the tool, it's probably the best tool to use. And I just caution you that trusts aren't for the mega rich. They're not for the super complex. These types of tools in the state of Delaware are for just your basic estate plans. Truly, they are the better tool to just make sure that you have outlined who's in charge and who gets what when you die. And trust avoid probate, which is really the point of the TOD deed, but you can do it in a much, much better way.
So what questions should someone ask themselves before deciding between these options?
So, you know, I think that first and foremost, you have to really be honest with yourself about what you're trying to accomplish. And what I mean by that is, what is your ultimate goal? So I like to say too to my clients, if I had a magic wand, what do you want me to do for you? If I could fix all your worries and concerns, whatever keeps you up at night, what would you want me to accomplish for you? And I think at the root of all of it is always, I want to take care of the people that I love. I want to make it as easy and simple as possible for them when I die. I want to make sure that I'm in control of my own wishes and that it's very crystal clear and black and white, so that I'm the decision maker on most things, so that my loved ones don't have to make a lot of decisions when the time comes. So clean, easy for my family, I think is the magic wand kind of request. So I think when you're thinking about, do I want a TOD deed or do I want a comprehensive estate plan, you have to be really honest and say, am I willing to spend the time, energy, attention, and money to create the best, most thorough estate plan that I can to take care of my family and the people that I love? I also think the second question that you should ask, besides like, what am I trying to accomplish, is, what's the total picture? Like, what are we talking about? Because I don't want you to just think about your home. I want you to think about your cash accounts, your retirement accounts, your life insurance, your stocks, your bonds, your CDs, your vehicles, your firearms, your stuff, your jewelry, and think of it as one overall cohesive picture, as opposed to singular assets and what you want to do with those assets. And I'll just say it one more time. I discourage you from overusing beneficiary designations, because one key to making sure your plan works as it is intended is to have cash flow and liquidity coming into your trust or your estate when you die, because there are always expenses. They could be house related expenses, they could be final expenses, you know, they could be even travel related expenses for your loved ones. It is important that there be a common pot of cash. And when you overuse beneficiary designations, there is no common pot of cash. Finally, I think making sure that you're really honestly asking yourself all of the what if questions. So what if one of my beneficiaries dies before me? What if I need long-term care in the future? What if my loved one is on needs-based government benefits? What if my loved one is going through a divorce or bankruptcy? And just truly thinking about those what if scenarios and realizing and accepting a TOD deed is not going to cut it. Because if those are the things that you truly are thinking thoroughly through, the only way to cover all of your bases is to use a more comprehensive tool like a trust.
If someone has already filed a TOD deed, is it too late to change course?
No, thank goodness. So, if you saw this when it came out last summer and you're like, oh, that sounds like a great idea, it can be undone. It's revocable. So you are still a good candidate to create a more thorough estate plan. We can still move your property over into a trust-based plan. We can revoke the prior TOD deed very simply. It's not a big deal. But I will share this story. I probably in the last couple of months had a handful of prior clients, that have asked me, do I need one of those TOD deeds? And they have been in a trust for years. I had one yesterday that's been my client for 15 years. And he's had a trust with his house in it for 15 years. And he read an article in the local newspaper about TOD deeds, and he wanted to talk to me about it. And through education, I just explained, you can ignore all of what you're hearing and seeing about TOD deeds. You already have the best tool, which is the trust. So, it goes both ways, Mindy. It goes, if you've already done a TOD deed, you can undo it and get into a trust. If you're already in a trust, you do not need a TOD deed, because your trust should already own your real estate and should already have provisions built in as to what you want to happen to your real estate when you die.
All right, Amber, what's one takeaway from today's conversation?
All right, takeaway I would say is sometimes too much information can create paralysis and inaction. You've probably heard the phrase like paralysis by analysis, and you like overthink it or you feel overwhelmed by all of this information. And so I think the biggest takeaway is get good advice. Just make sure that you're talking to someone that can really educate you about your options. I am never going to force someone to create a trust, but I do believe that once I've educated them about the trust and how it works, they then open their eyes and realize that they did have some major blind spots or some misconceptions about things. I am an estate planner and an elder law attorney. I believe in the services that we provide. I would never encourage anyone to go try to DIY this themselves, just like I wouldn't go fill my own cavity, and I just encourage you that if you want more information, if you feel overwhelmed by all of it, look for professional guidance and make sure you're having consultation with folks that know what they're talking about and are truly educated and passionate about serving the community and care about you and your goals and your family. And just think big picture and think about this as a comprehensive plan that isn't a one and done. Just because you signed a TOD doesn't mean you're done. Just because you put a beneficiary on your retirement account doesn't mean you're done. Estate planning has to continue to evolve. And as circumstances change, as laws change, you constantly want to be thinking about how can I improve my estate plan?
Thank you so much, Amber, for breaking down these important considerations. For our listeners, if you're considering your estate planning options and want to discuss your situation, please reach out to our office. We're here to help you navigate these decisions and create a plan that truly protects your family and your legacy. Thanks for being with us today on Off the Clock. If you'd like to learn more about us, visit our website at pwwlaw.com. Of course, you can contact us directly by calling 302-628-4140 or emailing info@pwwlaw.com. We're here to help you plan today to protect your families tomorrow. See you next time.
Thanks, Mindy.
Anything discussed on Off the Clock is for general informational purposes only and is not intended to create any attorney-client relationship. To obtain the most reliable guidance, listeners are encouraged to seek personalized advice from qualified professionals.